is a update from a lawyer, Denims and Kaceytron and Frogan, and I cannot wait to hear this. Apparently, it's one of the weakest defenses of all time, and they're about to get fucked by the long dick of the law.
Let's get into it right now with Hassan versus Orbiters. Okay. So let's show you guys the PP, right? I'm going to whip out my PP here, guys. And by the way, make sure you smash the like button.
Andrew Esquire, please start an OnlyFans. Please start an OnlyFans, Andrew, please.
Regardless of how you feel about the PP, make sure you smash the like button. It's very, very important. And also consider sharing this out on social media because it'll help us get going here as we race towards 2,000 subs. So we're in a continuation of Klein versus the Orbiters. As you guys all know, Ethan Klein is still engaged in a copyright infringement lawsuit, not defamation, not defamation, not criminal, whatever. This is a copyright infringement lawsuit against Kaceytron's, Denim, and Frogan. Now, we're not going to talk about Frogy Yogi because Frogy Yogi got a delay of game, and Frogy Yogi has a different lawyer. So
she has a lawsuit ongoing with McDonald's for cruel and unusual treatment of animals and their byproducts. She's been just eating way too much.
These two ladies have the same lawyer, which is going to be...
We'll cover her up.
Which is going to be a potential conflict. So as this thing goes forward, this is going to be a conflict of interest, without a doubt, between Kaceytron and Denims having the same attorney because they can make adverse statements against each other. So that's potentially problematic, right? And particularly if they come into a settlement arrangement, right? The settlement for one could involve selling out the other. So I think their lawyer.
So what he's saying is, in case the women get catty, they might have to get a new attorney, which I would not be surprised if Kaceytron and Denims, two people who are supposed to be on the same side, backstab each other immediately to save their own skin, as Denims already stabbed her own community in the back, which, to be honest, is fucking horrible.
Has a conflict, but somehow magically that lawyer agreed to this, and both of these girls agreed to this, which is very, very insane that this happened. So these two girls have answered the complaint, which means they received the initial legal paperwork and they wrote back. They said, here's how we respond. And what I want you to understand when we look at this, their defense, is that Denims filed her answer on the 14th and Kaceytron filed on the 15th. So this is something that happened just a couple days ago, right? So it's very fresh legally. Almost nobody has covered this. Certainly people haven't read it in detail. And what I did was I read the entire document, both of them. And I looked at what they had in common, and I wanted to present the defenses they have in common. Now, just so you understand, an answer
I cannot be fucked to do all that.
Has two things. It has a section which talks about the paragraphs in the complaint, and they go paragraph by paragraph, and they say, we agree with this paragraph, we disagree with this paragraph, or we don't have enough knowledge to agree or disagree. And we cannot say, right? Or it's a legal conclusion, and we cannot say because it's a legal conclusion. So that part, the part that talks about whether they agree, disagree, or whether they don't know about the entire complaint, which is very long, and they go paragraph by paragraph, that part is boring as hell. And to read through that is like reading paint drying. So we're not going to do that. What we're going to talk about is the second part of the answer, where they go into what's called affirmative defenses. So these are the defenses that they are raising to Ethan Klein's lawsuit. And an affirmative defense means even if Ethan Klein is right, I'm going to get away with it because X. So we're going to score all of those. I'm going to explain to you the law. I'm going to explain to you what each of those defenses is, what Denims is saying and what Kaceytron is saying. I'm going to explain to you which one it is. We're going to score them, and I'm going to tell you whether there is hope or whether there is cope with every single one. And I'm going to be very fair and objective, but I got to say, overall, you guys know this, and I've said this before, it is not in the favor of Denims and Kaceytron. It does not look good. But I'm going to tell you one by one, is it hope?
Well, yeah, because in this situation, they are living on a prayer that the jury weighs in their favor because they're women. This is the reason why Denims called for a jury, is because she literally is so delusional. She thinks that people outside of her bubble will agree with her. Sorry, sweetheart. The only people that agree with you are the gooners in your chat. No one in reality is going to say, oh, wait a minute, this guy's being mean to her just because she's a woman. Nobody's going to think that.
Or is it cope? So let's get into it. And so typically the specific responses are very generic, mostly non-committal denials, but the affirmative defenses are interesting. So we're going to focus on what's interesting because I don't like doing boring. And I'll show you, for example, this is the Denims complaint, right? I'll show you what I mean by boring. And I'm going to talk about this in kind of the fast facts versions and the other stuff. But you kind of see right here in the document, here's the beginning of the document of the answer.
Light mode is
Alexander Marwer Saber, aka Denims. And then they go line by line, paragraph by paragraph, saying, Paragraph 1 contains legal conclusions to which no response is required. Defendant denies the allegations in paragraph 2. Paragraph 3, defendant lacks sufficient knowledge. Paragraph 4, defendant denies, legal conclusions, lacks knowledge, admits.
Lacks knowledge should be like on every bullet point, you know, in perpetuity for anything that Denims or Kaceytron ever do.
So once again, in 10, they admit that. So you'd have to go back there and say, okay, what did they say? By the way, usually the only thing they admit is their name and where they live. Typically, that's it. Typically, they don't admit anything else other than their name. And that's all. That's what they'll agree to.
Okay.
Yeah. So what we're going to go through is not this part about admitting or denying, because that's kind of boring. What we're going to scroll down is all these affirmative defenses, which are down here. So failure to state a claim, fair use doctrine, express license, implied license, unclean hands, waiver, estoppel, justification and excuse, consent, innocent infringement, no injury and damages, good faith, inequitable conduct, unjust enrichment, latches, failure to register copyright, lack of notice, reservation of additional damages. So we're gonna talk more. The reservation we're not going to talk about because that's kind of a catch-all. But all the rest of them, we're going to go through and I'm going to score those. And for some of these, ladies and gentlemen, for some of these defenses, I genuinely believe their lawyer may have been high.
You know what's crazy about all the content I've been making lately? I know I told you guys I would never do politics, but the more and more I get informed, it's very fun to be informed in a space where nobody knows what the fuck they're talking about. I could be pressured into actually getting educated to talking about, or continue to talk about much more serious issues from a degree of enlightenment. Maybe I'll start doing a little bit of research off stream until I can confidently say that I'm very confident in all of my viewpoints. We'll see. Right now, I love, dude, people like Andrew Esquire who know what the fuck they're talking about. It's just compelling to watch. I actually love it. Maybe I'll read a book.
No, I'm not kidding. I don't know what the legality of marijuana is in the state in which they're practicing, but I do think that their lawyer could have been ingesting cannabis at that time. Now, I'm not saying it's negligent, but I'm saying it's very creative, if you know what.
And what's crazy is being a lawyer, like Andrew Esquire oozes charisma. He oozes charisma, and that is so good to playing to a crowd and a jury, right? Like, this is so important to the lawyers to be able to make people laugh, to hit those punchlines, to get people on their side to defend their clients. So it's very interesting, man. It's very interesting. Lawyers are scummy, but they're funny.
I'm saying, if you know what I'm saying. I looked at that, and I actually had to look up some of the defenses because they just pulled them out of nowhere.
Yep.
And literally, there are certain defenses they use that aren't even real in this area of law. I'm going to say that again, because I think you need to process this. Some of these defenses don't even exist for copyright infringement. It's as if this lawyer doesn't have a lot of experience in copyright infringement, or he wants to try some crazy stuff. And he's just throwing spaghetti at the wall and he sees what sticks.
Maybe it was ChatGPT.
Not saying he's committing malpractice or he's not competent. I'm just saying it's very creative. We're going to use that word. Okay. Very creative. That's all. So let's get into the key accusation. Oh, this is the wrong one. Boop, let me continue to go. First, failure to state a claim. Okay, so this is the first of the affirmative defenses. So the first affirmative defense is failure to state a claim. What failure to state a claim is it says even if all the facts are true, in a complaint, they do not establish a valid legal cause of action.
Okay.
This is saying they're going to be able to remove this on a motion to dismiss. Are they going to be able to argue that there is no claim here? This is an extremely weak argument. Yes, you can make the argument. It's not an impermissible or impossible argument, but it's extremely weak, and the likelihood of success is cope. The likelihood of success is cope for the affirmative defense of failure to state a claim. The motion to dismiss will 100% be denied.
Like a big L.
There's no way they're going to win on motion to dismiss. It's just not going to happen. Next is fair use. Now, this is their strongest of all defenses. And I give it a 5 out of 10, which is the most I'm going to give for any of the affirmative.
The reason why fair use is actually like plausible is because there actually is a scenario where I believe Denims and Kaceytron could just say, I was making a joke and appeal to my audience that I know they would like by me saying that I was maliciously reacting. But I would never maliciously react. It was just a joke. So the question is, are they going to allow that to be permissible of humor or not?
Defenses. So if accused, copyright infringement, use of the copyrighted material falls under the fair use exception and is therefore not infringement. This is a 5 out of 10. It is a toss-up. but the odds are in Klein's favor. So I
Interesting.
would say, if you really had to say, okay, in terms of arguments, because my strength of argument means, is this a killer argument? Is it like a totally a winner? And did they make it persuasively,
I
or did
want
they
this
not?
to be televised
I think it's
so
a toss-up.
bad.
They've got some
Like
facts
Amber Heard
that they
versus
may be able
Johnny
to
Depp,
argue.
man.
Some case precedent
be
they may be
insane.
able to argue. So that's why I give them a 5. I'm trying to be very generous. I'm trying not to be unfair here. For affirmative defenses, this is the one where they need to spend the most time. Everything else is not as strong as this. They have one other, which maybe you could argue, but it's not as strong as fair use. It's not as strong as fair use. So I think it's a toss-up in Klein's favor. Okay, next, express license. What this means is, did Ethan Klein give Kaceytron and Denims permission expressly to write it? So a plaintiff cannot claim infringement against a defendant who uses plaintiff's copyrighted work if the plaintiff granted the defendant an express license to use the work. So if you said, you can use this, it's okay, you can copy this, then you've got no express license, especially if you put that in writing. I think this is a weak argument because there is no, and the likelihood of success is unlikely because there's no written or specific license. There's nowhere where there is a written or specific license to use this content. Now, there's implied license. This is different. This is a little bit better. This is the second best defense in everything. The second best defense. Not perfect, but the second best. So you could argue about permission. And once again, the defense is permission to use something copyrighted material, to use some copyrighted material that is not explicitly granted, but it's inferred from the conduct of the owner or the circumstances. So this is a very generous ranking. Once again, I'm trying to be fair and professional, and I'm trying not to be biased here. So I'm trying to be very generous. Ethan Klein did at some point make a general statement about how he treats people using his content. However, he did not say, I give you permission to take the entire video with minimal content. And he also did not say, I give you permission to maliciously redirect traffic. So I think it's going to be difficult to argue that. However, it is easier to argue implied license than it is to argue express license. So this might be more possible. Once again, I give this at best, a 30 or 40% shot. And that would be me being very, very, very generous.
It's so sad that obviously these people were attempting to react as maliciously as possible and cause him to Ethan Klein, as well as, obliterate his traction to his video. The fact that it even has a 30% chance of being a plausible argument is actually, it's such a massive L for the internet because it's just awarding bad actors for their horrible behavior. I legit cannot believe they have that high of a chance. It sucks, but I understand it.
34% shot versus it's a toss-up, maybe like a 45% chance
the internet
on
really
fair use because you never really know which way it goes.
I
think 65% in favor of Ethan, 45% on the other way.
Because people
really
who
never
play
know.
fair
This one's more like 20.
Get left behind so quickly on social media.
Much lower. Yeah, he definitely. So an express license means in writing. He never gave them writing or an email or something like that. Implied means the conduct, meaning, oh, hey, we're all streamers. Every streamer copies somebody. No. In fact, and if you look at the overall environment, streamers strike each other all the time. Streamers strike each other over petty stuff.
They do.
Over stuff that's clearly fair use.
They do.
All the time.
They do.
All the time. So it's not streamer culture to do this. Unclean hands. I love unclean hands. It sounds so good. Like, your hands are unclean. Go wash them. Go wash your hands. Your dirty, unclean hands. So this one means someone has behaved badly in the specific situation they're suing about, so they cannot ask the court. So by asserting unclean hands, both Kaceytron and Denims are saying that Ethan Klein did something naughty and therefore he can't sue.
Absolutely
and
not.
I think what they're trying to say is
0%.
Him setting a copyright trap is unclean hands. The problem is it's not illegal or impermissible or dirty or not practical. Many people register their copyright. In fact, that's what you should do. In fact, you're encouraged to register your copyrighted material. So this seems like a very, very weak argument. I give it a 2 out of 10, and that's me being generous. And the likelihood of success being cope.
Yep.
Waiver. For waiver, what this says is the plaintiff waived a right relevant to their claim. So what right did Ethan Klein waive relevant to the claim? He hasn't waived anything. He hasn't waived anything at all. In fact, he's reserved all of his rights. So by arguing waiver, Casey and Denims and their lawyer are just making this up. I don't see where this is coming from at all.
I don't get it either.
I say, once again, this is a cope.
I don't get it at all.
Estoppel. Now, this one, I think it's arguable, but not likely. It's weaker than implied license. It's probably, it's probably not a 4.5. It's probably like a 3.5. But estoppel is a concept which prevents a plaintiff from asserting a legal claim that contradicts their prior actions or statements, particularly if it would be unfair to the defendant. So it's sort of like an implied license. You could say, okay, because of the conduct of Ethan Klein in the past and the implied license, there's sort of like an estoppel here that should come out. I still think it's unlikely. 20% would be very generous. 20-30% would be generous with this one. So I think this one, yes, you can argue it. Yes, it's better than, it's a hell of a lot better than waiver. I mean, waiver's a joke. Waiver's embarrassing. Waiver is like, what are you doing here? But estoppel, okay, I see it. It's not going to win. But once again, remember, guys, even with really crappy clients, and I trust me, guys, Denims and Kaceytron clients, they're very bad clients. I would never want them as clients. Never. You still have to try. And if they tell you to throw the, throw the kitchen sink in them, you do that. Okay, this is a funny one.
I want to really dig deep on what estoppel actually means. In law, estoppel prevents a party from contradicting their prior statements or actions if doing so would be unfair to another party who relied on those statements or actions. So I guess what they could say is, because Ethan was okay with Hassan reacting to that video, they assumed it would be okay for them to react as well, which I think is plausible if they didn't say, watch my video instead of his video, let's get this video fucked over in the algorithm. So I think under the certain circumstance, yeah, sure. But I think with the specific way they're going about it, I don't think it'll lean in their favor at all.
Justification and excuse. So defendant, that is Kaceytron and Denims, are saying that they admit to committing the crime, but they argue that the circumstances justify or excuse their action. Giving this a 3 out of 10 was really because I looked through the entire thing and I give them so many 1s and 0s. I had to try to give them some 3s because I wanted to be fair.
Sure.
But what is the justification? Because Ethan Klein is a bad human being, because he's a Yahtzee? The law doesn't apply differently to people because you think they're a bad human being subjectively. Mm-hmm. So I don't know what justification or excuse they have for copying it. Maybe they want to try to argue implied license or estoppel, and justification or excuse is a part of that, but I just don't see it as being a winning argument. I see it as sub 10% chance here. So this was a pity 3. This was a pity 3. It really should be a 2. Honestly, it should be a 2. But I gave it a pity 3. Okay, consent.
I give it a 0.
This is sort of like implied license as well. So they admit that the infringement was committed, but assert there are additional facts that justify or excuse the action. So once again, just kind of sort of like justification, and otherwise negate the plaintiff's claim. Did Ethan Klein consent to it through implication? Maybe. I think 10-15% chance at most. Likelihood of success, very, very low. And the argument, very weak. Innocent infringement. Oh, it's cute. It's an innocent infringement. It's a cute infringement. It's a type of infringement you can bring home to grandma, right? Right? No. Innocent infringement. It actually, in a weird way, I give it a 4 out of 10 because it's not actually a full defense. So what innocent infringement is it means it can reduce the damages that the court awards on a copyright infringement case. It is not a complete defense to liability. I think this one is plausible because they could take some sympathy or pity on them and reduce the damages. That is possible. The judge can do that. So they could say, okay, it is infringement, but it's relatively innocent, so let's reduce the damages and not have them totally high. So I think it's arguable. I think it's unlikely to make the damages 0, but I think it's arguable. It is arguable.
To reduce the amount of damage in a court can be awarded a copyright infringement case. It's not a complete defense of liability for infringement. We can mitigate the penalty of this. So I guess we can argue is the damage that we had on the video wasn't as big as he's making it out to be, which I think this is going to be actually very, very, very difficult to actually prove in court, is how much damage did they really have on the content nuke. And this is what really sucks, is that, like, for example, like, if a woman does something horrible to you, but you succeed in spite of them, they can argue that, well, just look, he didn't suffer at all. He was completely fine. And this one is actually, I think, I would give this a 7. Because to be honest, Ethan's career has kind of skyrocketed since then. So I can actually see this being their most likely defense that they weren't intending. And I think the question is, Can they prove that's what they intended? Because I think the intent is all that matters. And the intent was to disrupt. The intent was to destroy. And now with the death threats and treating them like they're like not even human is like, I feel like it's a plausible enough case to say, well, they may have not fucked over my career, but I don't feel safe leaving my fucking house. Because their intent was to destroy.
With that. Inequitable conduct. So there is a defense in patent law. Remember, this is copyright law. Copyright law is not patent law.
Okay.
Okay. So their lawyer is literally using an argument from patent law, saying that a patent applicant misrepresents or omits material information with the intent to deceive the Patent and Trademark Office. This is literally a
title of this video will be Denims and Kaceytron's court case leaked.
Non-existent argument, which is impossible, which
Banger
only applies
title.
for patents, not copyright. This is the dumbest thing that I've seen in a while, where a lawyer is going to argue law from an area that we're not even talking about. And he does it multiple times. This is one time. He does it another time too, which is like, it blows my mind. Maybe he's trying to make a unique argument and saying, even though this exists in patent law, you judge, I want you in this case to make this up. But what doesn't make any sense is this usually only applies to the patent office. So what are you saying? They deceived the copyright office? I don't think so. And it's properly registered. So what proof do you have of that?
Yep.
That's what's funny there. Okay, unjust enrichment. One party was unfairly benefited at the expense of another party without proper compensation. This is hilarious because the only people that were unfairly benefited were
Denims
the
and
orbiters,
Kaceytron.
were Kaceytron and Denims, right?
Yeah, dude. Denims had like 63,000 viewers during this. The fact that they even put this up there, I think this will work actively against them once Ethan gets to display how big of a benefit Kaceytron and Denims got since this stream. Like, Denims has been up consistently for like the next month after that by like 20 to 30% more viewers. Like that, this low-key made her career. Because nobody knew who Denims was before this shit, besides that one slot on OnlyFans. You know what I mean?
The only people who unfairly made money were
this
the
will
orbiters.
actually help
it
Ethan,
was
I
not
think. This will help Ethan.
Ethan Klein. How did Ethan Klein unfairly benefit? It makes no
bots?
sense
Maybe.
whatsoever. Where did his money come? Where did any money come from him? He didn't make anything. This is maximum copium. Saying that Ethan Klein was unjustly enriched. What are you talking about? Latches. The defendant can argue the plaintiff waited too long to sue and that the delay unfairly harms the defendant.
Nah, he went literally frame one. There's no way this works. He was frame one because he was preparing for this shit.
This one is another one that is so brain dead. This is completely brain dead. It's near impossible. I give it a 0.5. I wanted to give it a 0, but technically you can make this argument. It's not illegal, but this is what they're arguing, guys. They are arguing that Ethan waited too long to sue. Ladies and gentlemen, he literally sued immediately.
Yep.
He literally sued like days after their videos dropped.
Immediately.
You cannot possibly sue faster than he did. He had everything lined up and planned. Like everything. And he sued me. And they're trying to argue he waited too long.
Oh, and this is hard, by the way. Like, legit, I had to go through like 3 to 4 lawyers to get a case started. That shit took months, right? Like, there's no way you argue this in a court of law. No, this will get the jury and the judge to laugh in their faces.
That's their argument. It's fully within the statute of limitations.
Oh, yeah.
Like, fully within the statute of limitations. This argument, it's like, you're clearly just...
And I think statute of limitations for this type of case is like 2 years.
The lawyer is not doing anything illegal. He is entitled to make these defenses. But I'm also entitled to tell you that these defenses are absolute doggy doo-doo. Because they are doggy doo-doo. A big steaming pile. Not just a little Chihuahua pile. It's a Great Dane-sized pile of doggy doo. So let's just continue to sniff this mess, if you will. Failure to register copyright. This one I had to put at a 0. So they make the affirmative defense that while registration isn't required for copyright protection to exist, it's necessary to file a lawsuit for infringement. This is another argument that is brain dead. Because literally in the complaint itself, they show how they registered it, and they give proof of registration. It is literally impossible. The copyright was clearly registered properly. It was done by a lawyer. It was done in the proper way. There is no way this argument wins. It's a 0 because it's properly registered. You have all the proof of proper registration. So once again, I think he just copy pasted a list or just threw everything at the wall, but this is going to be absolutely blown out of the water. So lack of notice. Defendants were unaware and could not have known about the lawsuit.
I can't believe they even said
this is one I wanted to give another 0 as well.
This is
How
crazy.
are you going to be answering a lawsuit? So you've already answered the lawsuit and you're saying you have no notice?
That's insane.
What are you talking about?
Yep.
You know the lawsuit's happening and you have noted proper notice, etc. You had notice of the copyright,
Yeah, this
etc.
is the Temu lawyer, man.
Where's this lack of notice coming from? I don't understand this one. Complete cope. And typically, this is another one that lack of notice is typically only used for premises liability. So for example, this one typically works, for example, if you walk onto somebody's property.
Yeah, it's like, bro, you raised money for this. You knew it was coming. Did you raise money for a lawsuit that you didn't know was happening? You have written and provable knowledge, and like you have tweets of this shit saying, hey guys, I'm getting sued. I need money now. Unless you were just raising money for fun. It's so stupid.
And they have an alligator pit and they fall in the alligator pit. So if I, as a Florida man, right, if I build in my Florida man house, in Kissimmee, right, I build an alligator pit and I hide it under some leaves and you fall in the alligator pit. And I didn't tell you there's an alligator pit, but I invited you over. You'd say, hey, I had lack of notice, right? I had no idea that was there. Or if there's something I should have told you about, right? For example, let's say I had a bunch of plants that were really made of super brittle glass that if you touch the plant, they would shatter in a million pieces. And you touch the plant, it shatters, and I sue you. And you could say, well, I have lack of notice. You should have notified me not to touch the plant. So let's continue with the rest of the defenses here. Oh, wait, sorry. We got to the end. So lack of notice, not going to happen. It's cope. Failure to register, cope, impossible. Latches, cope. Unjust enrichment, cope. Inequitable conduct, impossible. Good faith, cope. No injuries or damage, cope. Innocent infringement, unlikely. Consent, unlikely. Justification, excuse, unlikely. Estoppel, unlikely. Waiver, cope. Unclean hands, cope. Implied license, unlikely. Express license, unlikely. Fair use, the only toss-up.
Yep.
And failure to state a claim of cope. You can see without a doubt, objectively, as I go through that, it is mostly.
And I think he was being incredibly fair.
Cope. It is mostly cope. We are not in a situation where this is something that I would say, okay, this is something where it's going to be a reasonable argument other than fair use. I think they got to stick to fair use as their core defense and focus on that. All the time on this other stuff, really not worth it.
Yep. No, I absolutely agree, man. I think Andrew was being incredibly fair. I think I was being incredibly fair. But no, bro, I'm not going to lie, bro. These bitches are copes. They better hope that people are buying their OnlyFans. That's the only way they're making money from here on out.